Stephen G. Scott presiding. All right, be seated, please.
Good morning.
All right, before the court this morning is State of Georgia versus Dennis Arnold Perry. It's Glenn County case number 0363063. The defendant's extraordinary motion for new trial. Mr. Holliday, you ready in that regard?
Yes, Your Honor, and I'll just ask for clarification. Can we take our
Yes,
mask
sir.
off when we get ready to speak?
Yes,
The
sir.
court reporter
Yes, sir.
wanted me to ask.
As long as you're comfortable, I'm comfortable. How about that?
Thank you, Your Honor. We're ready to proceed.
Okay, and I see, I do recognize Mr. Robinson that you have with you.
I will introduce the rest of the folks here at the table with me, if that's
Please.
all right. This is Jennifer Whitfield, our
Good morning, Your
co-counsel
Honor.
from the Georgia Innocence Project, my partner Philip Green,
Good morning, Your Honor.
and the aforementioned man who needs no introduction.
That's correct.
Mr. Pete Robinson.
Mr. Robinson, good to see you.
We also have with us, Your Honor, from our office today, Ben Watson.
Okay.
Who'll be
Very good,
behind the
Ben.
bar.
Well,
And he's the one who's going to keep us straight on the computer, I hope, because this is the first time for
all
us.
right, well, this system all going to be challenged. I know we have many folks participating on the WebEx, so we'll try to plow through it this morning.
Thank you, Your Honor.
And we have Mr. Conomo and Mr. Johnson.
Yes, Your Honor, for the state, Andrew Economo, Assistant District Attorney, and present also in the courtroom is John Johnson, Chief Assistant District Attorney, and Jackie Johnson, the District Attorney.
Mr. Johnson, good morning. All right, and let's make sure we have Mr. Perry. Mr. Perry, I see you. He might be muted.
I see you, Jeff. Good morning.
All right. Mr. Perry, can you hear me?
Yes, sir.
All right.
Yes, sir.
All right. You let us know if you have any difficulty with this video conferencing, whether visually or audibly, okay?
Yes, sir.
All right. And you're satisfied that we're doing it by way of video conference, is that correct?
Yes, sir.
Procedurally, gentlemen, I know in our telephone conference on Friday, I believe it was Friday, Mr. Kano had mentioned that he had a waiver argument he wished to make. If y'all want to go ahead and take that argument up, it's probably the court's intention to hear everything, to take that argument under advisement. And if we need to talk about when we're going to brief, or if we need to brief it after today's hearing, whatever the pleasure of the parties would be, we'll certainly accommodate you on that.
Your Honor, I would like to take the matter of appeal waiver up in the form of a motion in limine by the state to deny the extraordinary motion for new trial on the basis of appeal waiver, and I'm prepared to make that argument right now. Before we get into the evidence, the court may wish to take it under advisement, I understand.
Your Honor, I think our preference as the movement would be to hear the motion and have it presented as a defense. As I think we discussed in our conference on Friday, we've never been provided with a pleading that sets out the basis for the defense, the law in support of it. And so it would be our preference to just take it up as a defense. But let me say this, Your Honor, we'll take it up whichever way you want to, if you'd like to hear it
Mr. Conway,
first.
does it matter to you?
Doesn't matter to me, I'd be happy to do it later.
We'll do it as a defense. Are there witnesses, I'm going to be challenged on this, Mr. Hawley, are there witnesses that we need to put in the witness room that's currently signed in or is going to sign in, or are these all your folks from your office?
Your Honor, looking around, I see at least a couple of witnesses who are in the courtroom, and I've seen some witnesses who have signed on to the video at one point in time. They are not currently on.
And I'm going to leave the onus on the lawyers to determine whether I need to sequester them electronically or not. Y'all need to make that argument at the perfect time. I'm challenged in that regard. I've got a lot of help here. We can do it.
I would like the witness to sequester, however we can do that electronically, Your Honor.
All right. right,
Your Honor, can I take up one issue now?
You bet.
We're going to
Yes, sir.
sequester witnesses electronically,
yes, sir.
and that is, I need to inquire if the state intends to call Mr. Johnson as a witness.
The Assistant
The
District Attorney?
Assistant District Attorney, yes, sir.
Not at this time, but I may.
Your Honor, that presents us with a little bit of a problem
Okay.
as it relates to sequestering witnesses.
All right, with the understanding that you may call Mr. Johnson as a witness, any objections to Mr. Johnson be sequestered?
Oh, I do, Your Honor, because Mr. Johnson is going to be cross-examining one of their key witnesses,
Oh.
and I think he needs to be here to hear the evidence.
Well, he's wearing two hats now, so,
Right, Your Honor.
Your Honor, we would have no objection if he's going to, if the plan is for him to cross-examine one of the witnesses to sit in on the direct testimony of that particular witness and then to cross-examine the witness. That would not be objectionable to us.
to be sequestered, but he can come off sequestration.
He can come off
and
sequestration
examine.
and cross-examine the witness, yes, sir.
I think that's reasonable, Mr. O'Connell.
Whatever the court rules.
Thank you. So he'll be sequestered, subject to the witness that he's going to examine, he can come off sequestration.
Thank you, Your Honor.
What else?
Appreciate it.
So do we need to sequester these
Yes,
witnesses?
so there are witnesses. I see at least two witnesses in the courtroom.
All right.
And there may be others. I'm
Do you
not
have any
aware.
witnesses present other than the?
No, Your Honor, I don't.
Okay, all right. Ladies and gentlemen, those of you in the courtroom that have mentioned, that have been identified as witnesses, the rule of sequestration has been invoked, which means you cannot be present in the courtroom while other witnesses testify, cannot discuss your testimony with other witnesses, or allow them to discuss their testimony with you. Once you have testified, if you're excused, you're no longer under the rule of sequestration and can remain in the courtroom if protocol prohibits, permits. So with those witnesses in the courtroom,
Judge, I do want to make sure that everyone is aware. I have not been subpoenaed in this case,
okay.
and as trial attorney in this particular case, I would suggest to the court that my presence is needed, since I know what the facts of this case are. However, I understand the court's ruling.
I understand, Mr. Johnson.
I'll be upstairs, sir.
I appreciate that.
Judge Scarlett,
Yes, sir.
if I may, Ms. Whitfield has reminded me that our very first witness is our investigator in this case, and he has helped coordinate a number of the witnesses who are going to appear by video. We would ask that after he's testified, unless somebody intends to recall him, if he could just sit in so he could help us referee and keep the lawyers from trying to do that.
I'm satisfied with that unless it's appropriate time the state wants to object to that. Okay, all right. All right, logistically, Mr. Holiday, help me with some witnesses that we need to move to the lobby that may be.
I'm sorry.
If there are any witnesses that you have, since the rule of sequestration has been invoked, I do think.
Thank you, Your Honor. I see. I must confess, I don't know who Arizi is. Okay, that's, Audra, I'm so sorry. I'm just realizing that's not somebody's last name. That's your first initial
That's correct.
and your last name.
She belongs to
I'm
us.
very sorry. Trying to pick that.
At the moment, she's in the court.
Even worse, all the way around, I've missed you. Sorry
I just have
about
it on in
that.
my office.
Sorry about that. Subject to the others helping me, I don't see anybody else
Okay.
on who appears to be a witness, Your Honor. Thank you.
Okay, I think we're ready then.
May it please the court. Your Honor, my name is Phil Holliday, and I'm one of the lawyers representing Dennis Perry. And I want to thank you and let you know that we appreciate the opportunity to appear here today and present our arguments and evidence in support of Mr. Perry's extraordinary motion for new trial. I'd also like to say a special thank you for you making the necessary arrangements to make sure that Mr. Perry could be present by video today, given the challenges that COVID has presented for all of us. I'd also like to thank you for arranging for the live stream so that his family members could also attend remotely today. We very much appreciate it. Your Honor, we'd like to start with our motion with me presenting an overview of our argument and letting the court know about the evidence we intend to present today in support of that motion. That's all right, court. Dennis Perry has served more than 20 years in prison for the murders of Harold and Thelma Swain, crimes he did not commit. Mr. Perry has steadfastly maintained his innocence at all times. In late March of this year, Mr. Perry and his legal team obtained important new DNA test results that likely link another suspect, Erik Sparre, to the key piece of physical evidence that was found by investigators at the crime scene. A pair of unique glasses that those investigators had long believed belonged to the killer. Recognizing the material significance of this new evidence, both to Mr. Perry's innocence claims as well as to efforts to finally bring Swain's killer to justice, we immediately reached out and shared the new evidence with District Attorney Jackie Johnson. And on the screen right now is my email to Ms. Johnson, March 31, in which I thanked her for being willing to discuss the case with me that day and forwarded along to her right then both the new DNA test results as well as the test results for Mr. Perry that had been done back before his trial. Those test results for Mr. Perry excluded him as a possible contributor of the hairs that were found on the glasses at the scene. And as detailed in our motion, that testing implicates the mitochondrial DNA of Erik Sparre with respect to the hairs that were found on those glasses. We also shared that evidence right away with the Attorney General's office, who is defending against Mr. Perry's habeas petition that's pending in Coffee County, where he's incarcerated, and with the Georgia Board of Pardons and Paroles. We also reached out to and contacted the Camden County Sheriff's Office and Georgia Bureau of Investigation and offered the new evidence to them as well. Over the next 3 weeks, we had what we then believed were constructive discussions with Ms. Johnson about the facts and circumstances surrounding Mr. Perry's arrest, trial, and wrongful conviction. And put up on the screen now another email, the next one. First technical glitch of the day didn't take very long, did it?
No, it did not.
That's actually one before it should have been. At any rate, there was an April 10th email after Ms. Johnson and I had another productive call, which we very much appreciated her returning our calls. She asked me about certain evidence and information that was in the case, and we gladly provided that information to her. We also shared with her at that time our very strong belief that the new DNA test results, at a minimum, entitled Mr. Perry to a new trial. Our hope was that given the obvious material significance of the DNA evidence, the DA's office would at least agree to either consent to the motion, or if they couldn't do that, just at least not to oppose it. Unfortunately, those efforts didn't work out, which is how we got here today. In a call on April 23rd, Ms. Johnson advised me that to move the process forward, we needed to go ahead and file our extraordinary motion for new trial. That very same day, the 23rd, continuing in the spirit of cooperation, we forwarded our draft motion. First time in 35 years practicing law that we've done that. Mr. Robinson wasn't a big fan of going ahead and sharing what we were going to do, but we wanted to be as transparent as we could about it, Your Honor. And so Mr. Perry, the following Monday, 2.5 months ago now, filed his extraordinary motion for for new trial. The requirements for an extraordinary motion for new trial under Georgia law are set forth in the Timberlake case that we've cited in our pleadings, and they are straightforward. The new evidence must have come to Mr. Perry's knowledge since the trial. It was not owing to a want of due diligence by Mr. Perry that the evidence was not acquired earlier. The evidence is so material, it would probably produce a different result. The evidence is not cumulative only. If it involves witness testimony, the affidavit of a witness should be produced or in its absence accounted for. That's obviously not applicable here since we're talking about DNA test results. And then finally, the evidence must be offered for something other than simply to impeach the credibility of the witness. As set forth in our motion and the evidence accompanying it, the new DNA evidence reliably linking another suspect to the key piece of physical evidence found at the crime scene satisfies these requirements. One need look no further than the state's own actions since we filed our extraordinary motion to confirm that this new DNA evidence satisfies the Timberlake requirements and at a minimum entitles Mr. Perry to a new trial. We observed at page 1 of our motion when we filed it that we believed that had those new DNA test results tying another known suspect to the eyeglasses believed to have belonged to the killer been available back then, that it was so material that the state almost certainly would have directed its efforts toward building a case around those test results linking Erik Sparre to the murders. So what has the state done since we filed our extraordinary motion? Exactly that. 2 weeks after we filed our motion, Ms. Johnson issued a press release announcing that she had asked the GBI and that the GBI had agreed to reopen the investigation of the Swain murders in light of the new DNA evidence and the other evidence submitted by Mr. Perry in support of his new motion. Shortly thereafter, the GBI issued a press release of its own announcing that they had put together a multidisciplinary task force similar to what they'd done in the Ahmaud Arbery case in order to facilitate and expedite the reopened investigation. As GBI Director Vic Reynolds observed when discussing the GBI's reopened investigation into the Swain murders, there is nothing any worse than the potential of somebody innocent in prison. Nothing. We wholeheartedly agree, and the compelling evidence supporting Mr. Perry's innocence claim continues to grow. Last week, the state, in preparation for this hearing, in response to your Honor's order, produced witness interviews, exculpatory evidence that the GBI conducted with multiple individuals who have told agents that Mr. Sparre has made statements to them, or that they have overheard him making statements implicating himself in the Swain murders. And we expect the evidence to show that one of those interviews confirmed what the GBI and DA's office already knew, that within 1 year of the murders, Erik Sparre was recorded by his ex-wife's family bragging about being the MF who killed the two, and he used the N-word with an S on the end, in the church and threatening to do the same to them. And it has recently been discovered as part of the GBI's on reopened investigation. Mr. Sparre has made similar statements and threats to a number of people over the years. The court will hear that this evidence corroborates the materiality of the DNA linking Erik Sparre to the evidence found at the crime scene and the murders of Harold and Thelma Swain. The state recently has represented in a pleading filed with this court and reiterated during our recent July 1 status conference that it cannot in good faith take a position on Mr. Perry's extraordinary motion or respond to it until the GBI has completed its investigation. We strongly disagree. The issue before the court is not whether the GBI has or will be able to gather enough evidence for the state to successfully charge and prosecute Erik Sparre, or perhaps someone else, for the murders of Harold and Thelma Swain. Nor does Mr. Perry have to prove that the GBI's investigation will publicly exonerate him. It might, but that is not the test for a new trial. Instead, the straightforward issue before the court is whether the new DNA evidence satisfies the requirements for a new trial under Timberlake. It does. The state's own actions today prove that, and that legal determination is not dependent on the ultimate outcome of the GBI's investigation. The DA's office has represented in its public pleadings to this court that it, quote, is the state's duty to ensure that truth wins in all cases, close quote, and, quote, that it has no interest in keeping an innocent man locked in prison, close quote. But notwithstanding these statements and statements from the DA to the press just last week, that, quote, we need to look at these things and get to the truth of the matter, close quote, the DA, as Mr. O'Connor mentioned before we got started, is now asking the court to avoid looking at these things and avoid getting to the truth of the matter. Shortly after Ms. Johnson's statement appeared in the Brunswick News, her office advised Mr. Perry's legal team in the court, not in a public filing with the court, but by email. Finally, it is the state's position that this extraordinary motion is barred by Perry's appeal waiver, just as his petition for habeas relief was barred on that same basis. Your Honor, the truth in Mr. Perry's 20-plus year quest for justice and his EMT deserve more than technical defenses, procedural roadblocks, and further delay. He is entitled to have the evidence supporting his motion assessed and analyzed under the requirements of Georgia law as prescribed in Timberlake and to a decision on the merits of that motion. Let's talk a few minutes about the evidence that Mr. Perry has proffered along with this motion and that we will offer today in support of this new motion. The first Timberlake factor is the new evidence recently came into Mr. Perry's knowledge since the trial. We think this could not be more straightforward. As indicated in his affidavit that was attached to our motion, and as we expect him to testify today, Investigator Gross obtained a voluntary hair sample from Erik Sparre's mother, Gladys Sparre, on February 24th, 2020. On March 2nd, that hair sample was submitted to Mitotyping Technologies. That's the same nationally certified laboratory that the evidence and transcript from the trial shows the state used back in 2001 to do DNA testing on the hairs found on the eyeglasses that law enforcement collected at the scene. Mr. Perry's legal team received the new DNA results from Mitotyping Technologies on March 26, 2020, and as previously indicated, we provided those to the DA's office on March 31. As reflected in the test report, and as we expect forensic examiner Gloria Dimmick to testify today, those results reliably link the mitochondrial DNA found on the hair sample obtained from Erik Sparre's mother, Gladys Sparre, to the mitochondrial DNA of the hairs found on the glasses at the scene that were collected and preserved by Camden County Sheriff's Office Deputy Butch Kennedy and GBI Special Agent Joe Gregory. Nothing about the ongoing GBI investigation will change the undisputed facts that this new DNA evidence has only recently become known to Mr. Perry and that it was not available to him at the time of his 2003 trial. The analysis of the second Timberlake factor likewise does not depend on the outcome of the GBI's ongoing reinvestigation. That Mr. Perry only recently acquired this new DNA evidence is not owing to any want of due diligence on his part. As chronicled in his motion, and as the original investigators in the case testified at trial, and we expect them to testify again today, Butch Kennedy and Joe Gregory investigated hundreds of suspects during the years that they worked on this case. As a result, it would have been impossible and certainly cost prohibitive for an indigent defendant like Mr. Perry, or even the well-funded state of Georgia, to reasonably conduct DNA testing on all of the hundreds of alternative suspects investigated during the 18 years between the murders and Mr. Perry's 2003 trial. Tellingly, there is nothing anywhere in the record suggesting or indicating that law enforcement or the DA's office sought or pursued DNA testing of Erik Sparre as part of their investigation leading up to Mr. Perry's trial. And the indigent Mr. Perry obviously was in no position to compel Mr. Sparre or any other suspect to voluntarily submit to DNA testing. What the record does show is that Dennis Perry has also always maintained his innocence, and that he has at all times up until now diligently pursued proving that innocence. Following his arrest, Mr. Perry voluntarily agreed to DNA testing back in 2001 so that his DNA could be compared to the DNA testing that the state had mitotyping technologies do on the hairs that had been collected from the tape on the eyeglasses found by Butch Kennedy and Joe Gregory on the scene. That testing conclusively excluded Dennis Perry as a contributor of those hairs. That's a fact no one disputes. In fact, there was a stipulation at the trial so indicated. Following his conviction and the denial of an initial habeas petition, Mr. Perry was unrepresented by counsel for a decade. As detailed in the affidavit of Ms. Claire Gilbert, the Georgia Innocence Project, that was attached to Mr. Perry's motion, the Georgia Innocence Project agreed to represent him beginning March 2014 for the limited purpose of obtaining DNA testing of additional items of evidence collected at the scene. There had been some shell casings, Your Honor, and some buttons found at the scene, and the hope was that perhaps additional DNA testing could be done on those that might further elucidate who might have been involved in these murders. Unfortunately, that testing did not identify any additional DNA profiles that could be used for comparison purposes. In March 2018, the Georgia Innocence Project expanded its representation of Mr. Perry to include his potential habeas claims, including his actual innocence claim. Our law firm, King Spalding, was retained in August 2018 to assist in that effort. In connection with pursuing Mr. Perry's habeas claims, he and his lawyers have continued to diligently investigate and seek evidence in support of that innocence claim. It was those efforts that resulted in the discovery of the new DNA evidence, which is previously described, was shared with the state in both the habeas proceedings and with the DA's office within days of our receipt of that evidence. This court need not await the completion of the GBI's investigation in order to assess and conduct the analysis required to determine whether or not Mr. Perry's only recently discovering this new DNA evidence is due to the want of due diligence on his part. It plainly was not. Likewise, the evidence submitted along with Mr. Perry's emergency motion for new trial, and that will be presented today, shows that there can be no doubt that the third Timberlake requirement, that the new evidence is so material that it would probably produce a different verdict has also been met. After all, it was that new DNA evidence coupled with the other evidence that submitted along with Mr. Perry's extraordinary motion that prompted the DA's office, as it should have, to ask the GBI to reopen its investigation, and the GBI in turn, recognizing the significance of the evidence, almost immediately set up a multidisciplinary task force to conduct that investigation and is devoting significant resources to it. As discussed earlier, the evidence will show that investigation continues to develop substantial credible evidence supporting Mr. Perry's innocence claim. Mr. Perry and his counsel are fully supportive of the GBI's investigation. We've offered to and have provided information we have to them to help facilitate that investigation. That's an email from Ms. Whitfield to one of the agents leading the investigation, forwarding affidavits that we have found of witnesses that implicate Mr. Sparre. And as your Honor knows, we submitted those to this court under seal in order to protect the identity of the witnesses and to make sure we're not doing anything that jeopardizes the GBI's investigation. We wholeheartedly support it. And we remain hopeful that the investigation ultimately leads to charges against and the conviction of the Swain's actual murderer. But the issue before the court is not whether the investigation leads to actual charges and a conviction, but whether the jury would probably have rendered a different verdict if presented with these new DNA test results during Mr. Perry's original trial. The answer is an obvious yes, which is, of course, why the DA's office and the GBI understandably have reopened the investigation into the Swain's murders. As detailed in our motion and reflected in the trial transcript, the case against Mr. Perry was based largely on circumstantial evidence built around the testimony of Jane Deeb. What was not known to Mr. Perry's defense team, the court, and the jury in 2003 was that Ms. Beaver was seeking and was ultimately paid a reward, substantial reward, $12,000 for her testimony. What's on the screen now is a phone slip provided to Stephen or John D., which I assume is Mr. Johnson, in the DA's office, noting that on January 14, 2000, Your Honor, that's significant. Mr. Perry was arrested on January 13, 2000. The very next day, the state's star witness, only real fact witness implicating Mr. Perry, is calling and asking for a reward. That information was never disclosed, and we know she got paid because at the bottom of the screen is a ledger, the result of an audit of the sheriff's office, showing a payment to Ms. Beaver on April 3rd, 2003, approximately 6 weeks after the conclusion of Mr. Perry's trial. That non-disclosure is among the constitutional violations that are detailed in our habeas petition that we filed last year in a separate proceeding pending in Coffin County. The state had no evidence at the 2003 trial connecting Mr. Perry to the crime or the crime scene. In fact, the trial transcript shows the opposite was true. The only physical evidence from the crime scene that was available to be scientifically evaluated and assessed at the time of Mr. Perry's trial, the prescription for the pair of eyeglasses found at the scene and the DNA testing from the hairs found on them, excluded Mr. Perry. The eyeglasses did not match Mr. Perry's prescription or eye geometry. And the DNA evidence distilled from the hairs, as we talked about earlier, conclusively excluded Mr. Perry as a contributor of those hairs. No one disputes these facts, Your Honor. The significance of the lack of physical evidence linking Mr. Perry to the crime scene was certainly not lost on Mr. Johnson, who prosecuted the case. As a result, he was forced to speculate in closing argument that the eyeglasses found on the floor, inches from the Swain's bodies, were somehow there by happenstance or coincidence, suggesting that perhaps some unknown person who had nothing to do with the murders had absent-mindedly left them on the table in the vestibule at Rising Daughter Baptist Church at some unknown time before the murders. Or that maybe Mr. Swain had found them somewhere and decided to pick them up and put them in his pocket. Arguments, by the way, that were not supported by any testimony in the trial record. Given these facts, it is difficult to imagine any set of circumstances under which the jury would not have reached a different verdict had it been presented with the new DNA test results reliably linking another suspect, Erik Sparre, to the eyeglasses found at the scene. According to my typing technologies analysis, again, the same lab the state hired back in 2001 to do the original testing, and as forensic examiner Lori Demick is expected to testify, the DNA test results allow the company to, or allow Ms. Demick to exclude with 95% confidence 99.6% of the North American population as a contributor of the hairs. Dennis Perry is in that 99.6%. Erik Sparre cannot be excluded as a contributor. He is part of the 0.4% of the general population that can't be excluded. And as the GBI records submitted in support of Mr. Perry's motion show, he is the only person in that 0.4% to have boasted during a recorded telephone call within a year of the murders and numerous times since that he killed the Swains. He is also the only known person in that 0.4% whose ex-wife picked the eyeglasses found at the scene, inches from the Swains' bodies, out of a lineup set of 3 pairs of eyeglasses, noting that they looked like a pair he owned and lost. And he is the only known person in that 0.4% whose ex-wife reported that he left home one night during the week that the murders took place wearing a dark shirt and returned home wearing only a white t-shirt. In addition, as law enforcement records show, he is a welder, which would explain the pot marks on the glass's outer lens surfaces that were first observed and noticed by an optometrist that Mr. Kennedy and Mr. Gregory took the glasses to analyze them. And that analysis was later confirmed by the GBI lab, who actually found residue of welding slag on the glasses. It's also known that he owns guns, frequently described as being a racist, and reportedly, back in 1985, the time of the murders, was fond of wearing a pair of distinctive lizard skin boots that were important to the investigator because one of the witnesses, the witness who got the best look at the church of the murder, Ms. Danzola Williams, commented specifically on the unusual boots being worn by the murderer. As reflected in GBI records, those known facts led Assistant District Attorney John Johnson, Butch Kennedy, and Joe Gregory, long before anybody thought about and knew about these new DNA test results, to procure a search warrant and attend the search of Mr. Sparre's parents' house that took place back in 1986. In retrospect, we believe the evidence will show that but for what the evidence now indicates was a phony alibi, Mr. Sparre may have been charged and prosecuted for the Swain's murders long ago, even without the new DNA testing. On these facts, it is simply improbable that 12 reasonable jurors would have convicted Mr. Perry of these murders if presented with evidence reliably linking another suspect, Mr. Sparre, to the lasses found so close to Mr. and Ms. Swain's bodies. The evidence proffered in Mr. Perry's extraordinary motion and the evidence that will be offered through Ms. Dimick and others today demonstrate that the fourth Timberlake requirement likewise is easily met, since the new DNA test results are not cumulative of any evidence offered at Mr. Perry's 2003 trial. A review of the trial transcript reflects that Erik Sparre's name was not mentioned by anyone during the trial, and no evidence of his potential involvement in the murders was proffered or presented to the jury. Moreover, no evidence at all was introduced at the trial linking Mr. Perry or any other suspect to the pair of eyeglasses or other physical evidence found at the crime scene. In short, these new DNA test results aren't cumulative of anything that was presented at the trial. The fifth Timberlake requirement is technically not at issue here, as I mentioned earlier, since in this case the new evidence involves scientific DNA test results, not witness testimony. Nevertheless, and out of an abundance of caution, we attach the DNA results themselves and the affidavit of our investigator who procured the hair sample to the extraordinary motion. And finally, Your Honor, the sixth Timberlake factor. A new trial will not be granted if the only effect of the evidence will be to impeach the credibility of the witness. As I just said, no witness offered testimony at all about Mr. Sparre at the trial. And no one proffered or attempted to offer any evidence of his potential involvement in the murders. Accordingly, these new DNA test results are being offered as standalone, substantive, forensic evidence, reliably linking Mr. Sparre to physical evidence found at the crime scene, not to directly impeach the credibility of any witness who appeared at the trial. Back to where I started. GBI Director Vic Reynolds said it as well as it can be said. There's nothing any worse than the potential of somebody innocent in prison. Nothing. Dennis Perry has spent more than 20 years incarcerated for crimes he did not commit. Mr. Perry submitted, along with his extraordinary motion, and today will offer compelling, credible forensic and other evidence supporting his steadfast claim of innocence. These new DNA test results cannot be overlooked or downplayed. They are a game changer in every sense of the word. Not only as it relates to Mr. Perry's innocence claim, but also as it relates to, in the DA's words, getting to the truth, providing justice to the Swain family and to the perpetrator who did commit these horrific murders. This court, the DA's office, we all have a rare opportunity today, one that judges and lawyers seldom get. We can help an innocent man and his family's 20-plus year nightmare and set the wheels in motion to address and correct a miscarriage of justice. And there is no need to further delay justice for Mr. Perry and his family. It has already been too long coming. The issue before the court today is not whether the GBI's ongoing investigation of the Swain's murders will lead to the ultimate charging and conviction of Erik Sparre or anyone else. While we hope that the GBI's work does lead to that prosecution and successful conviction of the person responsible for the Swain's murder. The issue before the court today is not dependent on that outcome. The issue before this court today is far more straightforward and ripe for decision, whether the jury would have probably returned a different verdict in Mr. Perry's trial had they known about and been provided with the new DNA evidence linking another suspect, Erik Sparre, a man who we expect the evidence will show has repeatedly claimed responsibility for and bragged to others about having been involved in committing the murders, to the key evidence that is cited in the crimes. For the reasons outlined above, including the evidence already before the court and that will be presented at today's hearing, at the conclusion of the hearing, we're going to ask the court to grant Mr. Perry's extraordinary motion for a new trial, and we're prepared to call our first witness.
Thank you, Mr. Alden. Mr. Campbell?
Your Honor, may it please the court. The issue before the court today is not the guilt or innocence of Erik Sparre or anybody else. It's one simple thing. Should this court, can this court grant Mr. Perry's extraordinary motion for a new trial? That's it. That's the only thing that's been filed, and that's the only thing for decision before the court. This is not, according and in the position of the state, the forum for the determination of the guilt or innocence of any other party to this case. This is a very simple and narrow issue. Should the extraordinary motion for new trial be granted or denied? And it is the position of the state that regardless of what Mr. Holliday has said in his oration, this motion for new trial is barred by the doctrine of appeal waiver, Your Honor. Mr. Perry was convicted and stands convicted and is guilty today of the murder of Pastor and Mrs. Swain in their church in Camden County. He was found guilty by a jury in 2003. At that time, the state was seeking the death penalty against him for the murder of these two innocent persons. After the jury reached its verdict of guilt, a conference was held between defense counsel and Mr. Perry and the court and Mr. Johnson, in which Mr. Johnson announced that the state would give up the death penalty, a valuable right that the state of Georgia had. Seeking the death penalty would be given up and taken off the table, in exchange for which Mr. Perry would forego any post-conviction rights to appeal or to challenge that conviction that he had. And I think it's important that we look at the record in this case, which we will be presenting as evidence. The court engaged...
Just 1 second.
Yes, sir. Thank you. As I said, we are here today to recapitulate on a motion filed by the defendant Perry entitled Extraordinary Motion for New Trial, and this is critical, Judge, based on DNA evidence. I didn't put that in the title of the motion. They put it in the title of the motion. We believe that's barred for two reasons. One is an appeal waiver, and I was about to go through why I believe an appeal waiver obtains in this case. We know that he was convicted, Perry was, of the murder of the Swains in Camden Superior Court, in Glen Superior Court, although the offense took place in Camden County in 2003. That the state was seeking the death penalty, that he was convicted by the jury, and that it came time to submit the case of death or not to the jury. At that point, the defense counsel and the state met And the state determined, agreed to remove the valuable right that it had to seek death, to remove that, and to agree to sentences of life. So the following exchange took place. Mr. Westling, who was counsel for Mr. Perry, said, the judge said, would you read the appropriate code section into the record? And he said, yes, ma'am. When a person receives consecutive life sentences as a result of offenses occurring in the same series of acts, and any one of the life sentences is imposed for the crime of murder, such person shall serve consecutive 10-year periods for each sentence up to a maximum of 30 years. Mr. Perry already has a little bit over 3 years for credit as credit for time served, which would be applied to the 10 and 10. The court then said, okay, do you understand that, Mr. Perry? Yes, ma'am, the defendant responded. Okay, the court went on. Do you understand for the record what has occurred here? That the state has said that they will withdraw their seeking of the death penalty in this case, and that your attorney has basically said to the court, for and in consideration of that, that you're willing to give up your right to appeal the sentence and all possible appealable issues in the trial of this case. And for your giving up those rights, the state is willing to give up its right to seek the death sentence here. Do you understand that? The defendant, yes, ma'am. The court, okay, do you understand all the rights that you do have, and have you talked with your attorneys about it, and you clearly understand what's happening here? The defendant, yes. The court, okay, and do you want to enter into this agreement with the state today? The defendant, yes, ma'am. The court, I'm willing to accept that. Whereupon the sentence of the court was life sentences and not the judgment of death. I have also, and will present at the appropriate time, the sentences that the court entered in the case. The above named, this is on count 1, murder. The above named defendant being before the court having been convicted by a jury of the offense of murder in count 1 of the above indictment, the state, after conviction, having waived seeking the death penalty on the condition that defendant waive and give up all of his post-trial motions, including but not limited to any of his appeal rights, and that defendant agree to consecutive sentences, and having been given the opportunity to address the court then went on and sentenced him to a term of life. That same language appeared in count 2, the murder of Mrs. Swain. The same language on the condition that the defendant waive and give up all of his post-trial motions, including but not limited to any of his appeal rights, and agree to consecutive life sentences. Notwithstanding that, Your Honor, the record will show and the state will show, through documents from this own court, Superior Court, that in March 10 of 03, the defendant filed a motion for a new trial and said that a new trial should be given because of denial of due process and ineffective assistance of counsel. In response to that, the state filed a motion to dismiss because it said, in the responsive pleading, after return of the verdict and after consultation with the victim's family, the state's prosecutor made an offer to defendant through his counsel to agree to waive seeking the death penalty if defendant would agree to 2 consecutive life sentences and waive any post-trial motions, including but not limited to appeal rights. And what did Perry do in response to the objection raised by the state? He dismissed, Your Honor, his motion for new trial. He then went on in October of 2005 to file a petition for writ of habeas corpus in the Superior Court of Mitchell County, where he was incarcerated. And in that court, the court at that time said to him, read again to him that section of the petition that included the colloquy between Judge Williams and the defendant. and it said, in the instant case, the voluntariness of petitioner's waiver of right to appeal was specifically addressed by the trial court at its February 14, 2003 sentencing hearing as evidenced by the following colloquy. And I won't read it again because it's what I read in the record already. The court in Mitchell County, then the habeas court, then said, moreover, before this court, the petitioner testified that he recalled the trial court asking him questions about his understanding of the sentencing agreement and that he responded to the trial court's questions truthfully. The court finds, and I'm reading from Judge Moulton's order in the habeas proceeding, this court finds that the petitioner has failed to offer any credible evidence that his waiver of right to appeal was involuntarily entered. The court specifically finds that petitioner did enter a voluntary waiver of his right to an appeal, and as such, the instant petition provides him no basis for relief. Now, Your Honor is familiar with the waiver of appeal, but I want to call the court's attention to a case that was decided almost exactly a year ago by the Supreme Court of Georgia, Brandt, B-R-A-N-T v. State, at 306 Georgia 235, decided June 24, 2019. And it's almost identical to the present case. It says Georgia allows a defendant to enter into a negotiated agreement to forego the right to seek post-conviction relief as a means to serve the interests of the state and the defendant in achieving finality. So long as the waiver is voluntary, knowing, and intelligent, a criminal defendant may waive his statutory right to appeal a conviction in exchange for the state's agreement not to seek the death penalty. Go reading on in that decision. Where a defendant is eligible for the death penalty under existing law and enters into a plea agreement to avoid the possibility of receiving a death sentence, and this is critical, Judge, his guilty plea is not rendered involuntary by subsequent legal developments that make him ineligible for the death penalty. An important factor in that case is what the court concludes with. Contracts in general are a bet on the future. Plea bargains are no different. A classic guilty plea permits a defendant to gain a present benefit in return for the risk that he may have to forego future favorable legal developments. And cited in that decision is United States v. Vela, V-E-L-A, holding that an appeal waiver was not rendered invalid by a subsequent change in the law. It seems to me, Your Honor, that the only issue that can be raised by Perry today is whether that plea before that decision that he made before Judge Williams to forego the death penalty and get life sentences was freely, knowingly, and voluntarily made. That's the evidence that should be presented before the court today by Perry. And if he can prove that it was not knowingly and voluntarily and willingly made, then he may have a chance in a new trial. But once that has been established, and it has here over and over again, then he can't be heard to argue that he is entitled to a new trial. If the court chooses to hear evidence, however, Your Honor, let's look at the title of the motion. Extraordinary motion for a new trial based on new DNA evidence. The only thing we should be hearing here today, if anything, and I don't think we should hear anything but whether the plea was voluntarily or involuntarily entered into, not the plea, but the decision to enter into the death penalty for life sentence agreement. The only thing that should be heard from today from the defendant is DNA. That's it. We're not here to try Erik Sparre or anybody else. We're not here to try Dennis Perry again. He's been tried, he's been convicted, it's over with. The only thing that we are here today to hear, if the court chooses to hear that and wishes to defer ruling on the appeal waiver, is put up your DNA evidence and let's hear that. Because, Your Honor, I'm going to be objecting to anything that is not relevant to the DNA evidence. And that's all I've got to say. Thank you.
Thank you, Mr. Chairman. Spalding.
Your Honor, in light of your earlier ruling that you would allow us to present our evidence and take up the waiver motion at the beginning of the state's presentation, we're prepared to do that. I will say this, we disagree with just about everything Mr. Economy just said about the waiver, and Mr. Robinson is prepared to address that. If you have changed your mind after hearing and would rather hear that argument now, we're prepared to make it and go forward with it. We're also prepared to call our first witness. Thank you, Your Honor. Mr. Perry calls Ron Gross.
Is that live witness or is that?
He's a live one. He's here, Your Honor.
Ron Gross?
Ron Gross.
Start streaming.
What is this?
Mr. Sparre's birth certificate.
Let's see what that is.
Mr. Gross?
Yes, ma'am. Yes, sir. If you come up and would stand for me, please. Yes, sir. You'll just step up, remain standing, face my way. Raise your right hand, first one, Mr. Ed.
Do you solemnly swear or affirm the testimony you shall give to the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Please have a seat, sir.
Good morning.
Morning,
Please state your name for the court.
Ronald Grossi.
And Mr. Grossi, what's your current occupation?
I'm an investigator for the Georgia Innocence Project.
What are your responsibilities and duties with the Georgia Innocence Project?
As an investigator, several. I get involved in examining and assessing cases, identifying and interviewing witnesses, attempt to locate and collect new evidence that might be available. And I also assist the staff attorneys in case strategy and things like that.
Ms. Gross, can you spell your last name for the record, please?
G-R-O-S-S-E.
Thank you, sir.
Yes, ma'am.
Mr. Grossi, how long have you been an investigator for GIP? And GIP is Georgia Innocence Project,
Yes.
correct? How long have you been an investigator for GIP?
Well, I think I was officially hired in December of 2019, but I don't think I started working on cases till January, just after Christmas.
And what did you do professionally prior to joining GIP?
Well, coming out of college, I spent 7 years in the United States Army, and from there, I was hired as a special agent at the Federal Bureau of Investigation in 1990, and I retired in the end of August of 2018.
Do you have any, when you were with the FBI, did you have any special areas of focus?
Well, I was a white-collar crime investigator my entire career, but typically, they're voluntary, but there are ancillary duties, collateral duties, so to speak, and I did have a few of those.
And what were some of those collateral duties?
Well, I was a crisis negotiator, also known as a hostage negotiator. I was an applicant assessor in the FBI. That people are hired regionally, and they have special agents that go out to interview them, to assist in the hiring process. And I was also a member of the evidence response team, which in the FBI is similar to a crime scene investigative unit at the state or local level.
I'd like to ask you a little bit more about your participation in the evidence response team, but first, could you just describe for the court a little bit about the training you received when you joined the FBI?
Yes, ma'am. Well, it was sometime after, it wasn't 9/11 yet, but sometime in the early 90s, the FBI decided they did have evidence teams around the country, but they decided that each field office needed to have their own evidence response team. So in 1995, the Columbia Division, where I was assigned, formed an evidence response team, and I was one of the first members there. The training consisted of initial basic type training was 2 weeks, 2 weeks at Quantico, at the training academy. And then there were several specialized schools that I attended along the way. And the team would train about once a month for a full day. And in addition to, going out and actually working cases.
And as part of, approximately how long did you serve as a member of the FBI's evidence response team?
You know, I'm thinking it was about 20 years. I'm not exactly sure when I got off. Probably about 20 years.
And was the evidence response team solely responsible? Was the evidence response team the team called upon for collecting evidence for the entire office where you worked?
Yes, so sometimes, depending on the size of the case, the investigators might do their own, and the type of evidence, they might do their own collection. But if it was a specific type of evidence or a skill that they didn't have, or it was a large case where they wanted help organizing and submitting the evidence, they would call on us. So yeah, we were available to the whole state, and we were also available to assist in state and local cases as well.
And did they ever call upon you to travel in order to collect evidence?
Yes.
And is there any, could you share with us an example of what that travel might entail?
Well, after the bombing at the Olympic Park in Atlanta, there were several teams that were deployed. There were several that were already there. I was already there. I was in Savannah at the time, and they called the whole team together to come to assist after the bombing in Atlanta. We deployed to the Pentagon after 9/11 to assist in the search there, and also to the Fresh Kills site on Staten Island after 9/11.
As part of your participation in the evidence response team, were you trained specifically on the importance of evidence collection?
Yes, not only as a member of the evidence response team, but my training at Quantico as an agent was, evidence is a big part of what we do.
And were you trained on the importance of evidence preservation?
Yes.
And were you trained on the importance of avoiding evidence contamination?
Yes.
Since you stopped participating in the evidence response team, did you continue to attend trainings on crime scene investigations?
No.
While working at GIP, have you been working on Mr. Perry's case?
I have.
And in your investigation, did you come across the name Erik Sparre?
Yes, ma'am.
And who is Erik Sparre?
Objection, Your Honor, irrelevant.
Overruled.
Mr. Sparre, I've read the entire case file, and I know that he was at one point identified as a subject of the case, or suspect, and in our language it was subject of the case, and he was cleared at one point, but he continued to be a subject of the Georgia Innocence Project investigation.
Did you come across the name of Miss Gladys Sparre?
I did.
And who is Miss Gladys Sparre?
She's Erik Sparre's mother.
And how do you know that?
Well, from the case file, from interviewing people in the case, other witnesses, people that were married to Erik Sparre who knew her, and looking at his birth certificate, which identifies Gladys Sparre as his mother.
Your Honor, I'm marking Defense Exhibit 1. May I approach?
Yes, ma'am.
Mr. Grossi, what is Defense Exhibit 1?
It's a certificate of vital record, and it appears to be the birth certificate, the certificate of live birth of Erik Christensen Sparre.
And does Mr. Sparre's birth certificate indicate who his parents are?
Yes.
And who are his parents?
Objection, Your Honor, to reading from a document that has not been admitted into evidence.
Your Honor, I'd like to move Defense Exhibit 1 into evidence.
I object to that on the grounds of relevance, Your Honor.
Admitted over objection.
I'm sorry, Your Honor, I missed that.
Admitted over objection.
Thank you. Could you please tell the court who Mr. Sparre's parents are according to the vital records birth certificate?
Yes, ma'am. The name of father is Frederick John Sparre, and the maiden name of the mother is Gladys Lillian Metz. But in the section marked informant signature under parent, it's signed Mrs. Gladys Lillian, in parentheses, Metz Sparre, mother.
As part of your investigation, did you go to Miss Gladys Sparre's home?
I did.
And why did you go to Miss Sparre's home?
Well, for two reasons, I suppose. One was as part of our continuing investigation, and I always like to interview the subject. So that was a possibility, although I knew there were some reasons not to, but that was one reason. And the other reason was in an attempt to collect DNA evidence from either Mr. Sparre or Mrs. Sparre or maternal relative of Mr. Sparre.
Tell us what happened when you arrived at Ms. Sparre's home.
I knocked on the door. Woman came to the door. I'd never met Mrs. Sparre before, so I identified myself as an investigator with the Georgia Innocence Project, and I told her the reason I was there was that the Georgia Innocence Project represented Dennis Perry, who was incarcerated for the murder of 2 people in Camden County in 1985, and I asked her if she was Mrs. Sparre, and she said yes. I asked her,
Objection, Your Honor, hearsay.
I asked her if she was the mother of Erik Sparre. She said she was. I asked her if I could talk to her, and she invited me in the house. Went inside the house. We sat down in it's a small place, and we sat down right there in the kind of the foyer of the house and talked.
Did you explain to Ms. Sparre that Dennis Perry, the individual on whose behalf you were working for, was the person who was convicted of the murders of Harold and Thelma Swain?
Yes, I did. I told him that he had been convicted, and that her son, Erik, was considered a subject, and she immediately told me that she knew of the case. She knew that 2 people had been killed in, I think she said in Waverly in a church. She said, my son was arrested for that, but they cleared him as a suspect. I don't know if she used the word cleared, but she said they decided that he...
Pose it in the hearsay objection.
I have a continuing objection, Your Honor.
As to this line of question, I do sustain the objection.
Only line, Your Honor. After explaining to Ms. Sparre why you were there and who Dennis Perry is and why specifically you were looking at her son, Erik Sparre, did you talk to her about DNA?
I did.
Please describe for the court that conversation.
Well, I asked her if she knew what DNA was. She said she did. She said it's in your blood. I said, yes, it's in your blood, but it can be in other places in your body as well as in your hair. And I asked her, I told her that if we could obtain DNA evidence from her or her son, it could exonerate him or could eliminate him as a subject. So she said, I know my son didn't do this, and I said, well, can I get a sample of your hair? She said yes, and she started to pull her own hair out, and I could tell it wasn't easy for her, and I didn't want her doing that anyway. I said, no, don't do that. She said, well, you can do it to me, and I said, no, I don't want to do that. I said, I don't want.
When she said you can do it, what did she mean by that?
I could pull her hair out, and I said, no, I'm not going to do that. I said, but if you don't mind, if I cut a few hairs from a place in your head where it won't be noticeable, would that be all right? She said, yeah, sure.
And after she agreed, what happened next?
Well, I had brought with me some a box of latex gloves and some new scissors that I had that were still in the package, and some new envelopes that I had purchased. And I picked a spot in the back of her head, which I thought would not be noticeable if I took a sample of her hair, and I cut some hairs and I put them in the envelope. I sealed it up, dated it, initialed it. We chatted a little bit longer, and I told her the hairs would be sent to a laboratory for examination, and she asked me she said, would you call me and let me know what the results are? I said I would, and I left.
And after you left with the sealed envelope, Mr. Grossi, what did you do with it? She lives in Waynesville. I'm from Columbia, South Carolina. I got in my car with the sample that I cut in the sealed envelope, and I drove back to my house. Your Honor, may I approach? Mr. Grossi, I just handed you what's been marked as Defense Exhibit 2. Do you recognize this?
I do.
What is it?
It's a copy of a FedEx receipt.
Is it a true and correct copy of the receipt?
Yes, I noticed my initials on there.
Your Honor, I'd
it
like
is.
to move Defense Exhibit 2 into evidence.
No objection.
Submit the objection.
And what is the significance of Defense Exhibit 2, Mr. Grossi?
Well, upon your instruction, I took the sample, the sealed envelope with the sample inside it, to the local FedEx office, and I put it in overnight FedEx
envelope and mailed it to Mito Typing Technologies in State College, Pennsylvania.
And is that the receipt you obtained in exchange?
Yes.
From the time you collected Ms. Sparre's hair sample and placed it in a sealed envelope until the time you put it into an envelope at FedEx, did that sample remain in your possession?
Yes.
No questions, Your Honor.
Thank you, sir. You may stand down to your seat.
Thank you.
And, Your Honor, Mr. Gracie is a witness who we had asked to be allowed to remain in the courtroom despite the incarceration order so that he could facilitate witness testimony.
Any objections, comment? You may remain full.
Your Honor, while I'm at the podium, if I could just handle one more housekeeping matter, which is you may have noticed that myself and a few other members of our team may be using our cell phones from time to time.
Yes.
And I just wanted to assure you that that's only because of COVID and we ordinarily would not be
I understand.
communicating that way.
That's such.
Thank you.
Thank you for bringing that language. Mr. Holiday.
Mr. Perry would call Gloria Dimmitt his next witness.
This is the DNA expert.
This is the DNA.
Then can I have
expert.
Mr. Johnson come down, Your Honor?
Yes.
If you'll wait, Mr. Vicente, we'll get you.
Yes.
And Your Honor, she will be back.
Okay, all right.
Good morning.
Can you hear me okay?
I can.
Okay, great. If you will, please introduce yourself and state your full name for the court and for the record.
Gloria Jean Dimmick.
And what is your occupation, Ms.?
I'm a forensic examiner.
And what does a forensic examiner do, for those of us who aren't aware?
So you broke up just a little bit. I believe you asked what I do as a forensic examiner. Is that correct?
Yes.
Okay. So in the role of a forensic examiner, I'm responsible for document of receipt of evidence, processing and testing that evidence in the laboratory to generate mitochondrial DNA. I also do data analysis, interpretation of the data and comparison, as well as write reports and provide expert testimony.
Okay. And where do you work, Ms. Devon?
Mitotyping Technologies.
How long have you been there?
21 years.
And besides the responsibilities that you just outlined for us, do you have any other roles and responsibilities for Mitotyping Technologies?
I do. I serve as the quality manager, and in that capacity, I assure that we are compliant with our accreditation guidelines. I'm also the technical leader, so I assure the scientific soundness of our methods, as well as any results leaving the laboratory. So I direct and oversee casework.
Thank you. And before we talk more about you, can you tell us a little bit about the type of lab that Mitotyping Technologies is?
So Mitotyping Technologies is a private laboratory, and our primary focus is forensic mitochondrial DNA analysis. We do also accept samples from private entities. So we have tested samples of historical importance for institutions such as the Smithsonian.
And you mentioned mitochondrial DNA analysis. Is that a subject matter we're going to discuss today?
I'm sorry, could you repeat that? I didn't hear the end of the question.
Sure. We're going to discuss mitochondrial DNA analysis today.
Yes.
Very good. Is Mitotyping Technologies, is that an accredited lab?
Yes, we are.
And what does that
We've
mean?
been-
I'm sorry, go ahead. What does that mean?
So we've been accredited since 2001, and being accredited, we're audited by an auditing body to assure that we're following all of the guidelines necessary to complete the tasks and do our course of business.
Is the lab proficiency tested?
Yes, that's one of the requirements of the accreditation body and our guidelines, that we are proficiency tested twice a year.
And can you tell us what proficiency testing means?
Yes, we receive samples from an external source that we're required to process and generate mitochondrial DNA information. And then we submit our results to that proficiency test provider. And they basically grade our work or tell us if we have generated the appropriate information.
And has the lab ever failed a proficiency test at any time?
No, the laboratory has never failed a proficiency test.
Are there many labs in the United States like your lab?
So there are other facilities that do mitochondrial DNA testing. That would include the FBI, AFDIL, which is the Armed Forces DNA Laboratory. They do missing in action service people. There are a handful of other private laboratories, a few state labs, and of course there would be laboratories at universities that would be conducting research.
Okay.
So it wouldn't be for a forensic application, but they would be using the same procedures that we use.
Can you give us sort of an approximation of the number of mitochondrial DNA analyses that mitotyping has done?
So we've had well over 1,000 cases in the 21 years that we've been in business. And we processed thousands of samples for those cases.
Okay, and how many states in this country has mitotyping technologies conducted analysis before?
So we've received samples from all 50 states for testing.
And does the lab perform mitochondrial DNA extraction and analysis for international groups or agencies?
We have received samples from Israel, Australia, New Zealand, the UK, Canada. So we do receive samples internationally for testing.
And are you hired to do extraction and analysis in criminal cases?
Yes, that's our primary focus.
And are you ever hired by the prosecution in criminal cases?
We would be hired the majority of the time by prosecution because of the burden of proof is on the prosecution.
And we'll get into this in a little more detail, but have you been hired by John Johnson from the Glenn County District Attorney's Office?
So we were hired to work in a case submitted in 2001, and it was a joint agreement between prosecution and defense at that time. And so the testing was court ordered, and prosecution and defense were working together.
And before we get into your qualifications and your experience, maybe we can give a little bit of an overview of the topics you're going to discuss. Well, first of all, are all the opinions that you are going to offer here today, do you hold them to a reasonable degree of scientific certainty?
Yes.
Do you have a series of demonstratives that can help aid in your testimony in explaining some of the concepts we're going to walk through?
Yes.
Okay. Let's look at the first one, if you will. It's kind of an overview of your opinions. If you can, Mr. Watson. Thank you. Can you see that okay, Ms. Dimmick?
I can.
Okay. And will you please just very briefly give us an overview of the topics that you're here to discuss?
So I'm going to be discussing mitochondrial DNA analysis, and then more specifically discuss a case that was submitted in 2001, where hair samples were submitted from crime scene glasses. Then I'm going to discuss a case that was submitted in 2020, which contained the Erik Sparre hair sample. And lastly, I'm going to discuss the significance of a match between a mitochondrial DNA profile of an evidentiary or question sample and that of a known sample, and more specifically the known sample from Sparre.
Okay, thank you very much. And let's take a moment before we get into some of these subject matters and go over your education, your training, and your experience for the court, okay?
Okay.
I know you gave us a copy of your CV, and instead of walking through that, do we have a demonstrative that gives sort of a summary of your education and your work experience?
Okay, I can see
I
that.
can see that. And first of all, Mr. Nick, where did you go to college?
I'm sorry, you broke up just a little bit there.
Where did you go to college?
Penn State University.
And did you do any graduate work after college?
I did.
What did you get your undergraduate and graduate degrees in?
So I have a Bachelor of Science degree in Nutrition Science, as well as a Master of Science degree in Food Science.
And after graduate school, what work did you do?
So after college and graduate school, I was employed at Penn State University, and I was there for almost, it was a little bit over 12 years. That does include my graduate work. And at Penn State, I held various research positions, but most notably, I worked in clinical chemistry, virology, and the core DNA sequencing facility for the university. And following my tenure at Penn State, I was hired by Mitotyping Technologies in 1999, and I've been here ever since. And then for a very brief period, I did take a part-time job with an established company, Salometrics, and my role there was to assist in bringing on a DNA analysis laboratory.
Okay, and you told us a few moments ago that you have been with Mitotyping Technologies for a little more than 20 years. Have you, over the course of that time period, received training sufficient to support your work as a forensic technician, an analyst, and ultimately a forensic examiner?
Yes, there is a very stringent training program, again, that is outlined in accreditation standards and requirements, as well as a requirement for annual training. So part of that is review of documentation, attendance to meetings such as forensic conferences, attendance at workshops, as well as possibly webinars.
Okay, and as part of your regular work at Mitotyping, Ms. Dimmick, do you conduct mitochondrial DNA analysis yourself from specimens such as hair samples?
So I didn't hear the end of that question. I'm really sorry. I heard the beginning of it.
I can re-answer. As part of your work at Mitotyping Technologies, do you regularly perform mitochondrial DNA analysis of biological specimens, including hair samples?
Yes, as a matter of fact, hair samples are the most common sample type that we receive for testing.
And do you have significant experience yourself with mitochondrial DNA analysis sufficient to render you an expert in that field?
I do.
Okay. And do you have a slide that outlines your publications and affiliations with professional organizations?
Yes.
And have you been affiliated with professional organizations?
Yes, I'm a member of the American Academy of Forensic Sciences, as well as the American Association for the Advancement of Science. I am a past member of the Institute of Food Technologists.
Have you published any peer review articles pertaining
Yes,
to...
I have, specific to forensics, I have 3 publications that address research in mitochondrial DNA.
And have you received specific training regarding mitochondrial DNA sequencing?
Yes, and again, that would be that continuing education requirement. So I've attended forensic conferences both in the United States and internationally. I've also attended workshops and webinars that focus specifically on mitochondrial DNA and testing methods.
Okay, and have you testified in your capacity as an expert witness before in cases involving mitochondrial DNA?
Yes, I have.
Have you been qualified as an expert witness in several states?
Yes, I have.
Have you ever testified, well, first of all, approximately how many times have you testified as an expert witness on mitochondrial DNA?
So this will be, I believe it's the 8th time that I've testified. One of those times is missing from my resume. It hadn't been updated from a previous testimony. But this is about the 7th time that I've testified.
And for all of the, I believe, 7 cases that you've testified in before, have you ever testified on behalf of a defendant in a criminal case?
No, and again, the burden of proof is typically on the prosecution. So that's typically where we would testify.
And in the cases in which you have testified, have you always testified for the prosecution?
That is correct.
Okay. And do you stay current and up to date with advances and developments in the science that you're here to testify about?
I do.
Your Honor, at this time, we would proffer Gloria Dimick as an expert in DNA sequencing and analysis.
Wish to board our witness, Mr. Johnson.
No, Your Honor, thank you.
She's so qualified.
I'm sorry, may I inquire to the specific? I apologize.
Sure. If you repeat it again, please.
At the specific area she's qualified in.
Sure. DNA sequencing and analysis, and specifically with respect to the sequencing and analysis of the two question hair samples found at the scene of the crime, and also against the hair sample obtained from Ms. Spalding.
Satisfied, Mr. Johnson?
Yes, sir, thank you. I'm sorry.
Okay, Ms. Dimick, let's talk briefly about DNA and the different types of DNA testing that can be performed. Do you have some demonstratives that can help us walk through these subjects?
I do.
Okay. And let's look at the first one. It's up on the screen here. If you can briefly give us an overview of number one, what DNA is, and then number two, are there different types of DNA?
So DNA is a genetic inherited material. It's sometimes referred to the blueprint of life because it contains a complete set of instructions for the makeup and functioning of a human. And the cells that comprise the body actually contain 2 types of DNA. And I'm going to highlight 4 differences between them, which is location, copy number, inheritance, and what they code for. So the first type of DNA is located in the nucleus or the core of the cell. And there are 2 copies present, one that is inherited from your mother and one that is inherited from your father. And this DNA contains information that makes you a unique individual. It could contain information such as eye color, hair color, and skin tone. The second type of DNA is located outside of the nucleus, and it's found in an organelle called the mitochondria. And the mitochondria are the powerhouse of the cell. So in each cell, there are multiple mitochondria, and there are hundreds to thousands of copies of mitochondrial DNA. And that DNA specifically contains information for energy production. It is inherited from mother to child unchanged. So a mother and her children, as well as anyone along a maternal lineage, will have the same mitochondrial DNA type or profile.
Okay, so when we're thinking about nuclear DNA, there are 2 copies in each cell, and that's inherited by both parents.
Correct.
And with mitochondrial DNA, that's inherited only from the mother, I believe you said.
That is correct.
And can you tell us about, well, first of all, what is STR, or autosomal testing?
So STR, it stands for short tandem repeat, and that's the kind of information that you would generate if you were looking at nuclear DNA.
Okay, and what types of biological specimens can you do that type of testing on?
So nuclear DNA, you would be able to test biological materials. That would be, for example, blood, stains, bones, skin cells, fingernails, things of that nature.
Okay, can you do nuclear DNA testing on a hair sample that does not have the hair follicle?
No. So mitochondrial DNA testing is reserved for samples that is not suitable for nuclear typing, and that would include naturally shed hairs or hair shafts. There's simply not enough nuclear material present to generate a profile. It would also include samples that are degraded or exposed to environmentally challenging situations. For example, charred remains from an arson investigation most likely would not be suitable for nuclear typing, but it would be suitable for mitochondrial DNA.
And why is it that those types of samples are suitable for mitochondrial DNA analysis when they're not for nuclear testing?
So again, it has to do with the fact that nuclear DNA, there's only 2 copies present per cell. And for mitochondrial DNA, there's hundreds to thousands of copies per cell. So just based on the starting material alone, the nuclear DNA is going to degrade more quickly than the mitochondrial DNA.
Okay, so when we're thinking about forensic issues, is mitochondrial DNA then important for forensic purposes?
I'm sorry, is mitochondrial DNA what?
Important for forensic purposes. In other words, can you get information from it?
Yes, you get information from mitochondrial DNA.
Okay. And do you have some demonstratives that can help you explain the structure of mitochondrial DNA and the types of information that you can get from it?
I do.
Okay. Let's look at the first one. Tell us what we're looking at here at the top left, Ms. Dimick, and if you can, walk us through the structure of the cell and then explain that, please.
And so again, we're looking at a cell that would be found in the body. And as you can see, there's a single nucleus, which is in the center of that cell. The nucleus is sort of the control center for the cell. Outside of the nucleus, but in the cytoplasm, you'll find that small organelle, which is the mitochondria. And as you can see, there are multiple mitochondria per cell.
Okay. And if you would like me to keep going with the slides that you have here, just give me the heads up and I'll click forward.
Yes. Within the mitochondria, you'll see a small circular structure, and that's mitochondrial DNA. And again, there's multiple copies of mitochondrial DNA per mitochondria. So if we take a closer look at that structure, that circular structure, the majority of it is very gene dense, and highly conserved. It's what's considered a coding region. And what we would focus on for forensic mitochondrial DNA analysis, which is depicted by the red dot, is actually a non-coding region. And so within that non-coding region, it's also referred to as the control region. But the areas that we focus on are called hypervariable regions 1 and 2. And this is where the most differences would be found between unrelated individuals.
Okay, and tell us, can you explain for us the concept of finding base pairs in a DNA sequence?
I can. Okay, so looking at the structure of DNA, it's present in what's called a double helix, where two strands of DNA are intertwined. Now, if we untwist that DNA, what we get is something very similar to a ladder in appearance, where the rails or sides of the ladder are the DNA backbone. And if you look at the rungs of the ladder, that consists of the nitrogenous bases, which make up DNA. So there are actually 4 bases. Shorthand notation is A's, C's, G's, and T's. That's adenine, cysteine, guanine, and thymine. And if you look closely, again, at the rungs of the ladder, you will see that adenine, or A, always pairs with thymine, and cysteine always pairs with guanine.
Let me ask you this, Ms. Dimmick. When you're doing your analysis and trying to determine whether a known sample is a match and can be included, or whether it can be excluded, is this the information that you're looking at and comparing with samples?
Yes, so the information that we are looking for is actually the order of these A's, G's, C's, and T's along these stretches in the hypervariable region 1 and the hypervariable region 2.
What is the Cambridge standard?
Hypervariable region 1 and 2 actually consist of about 783 base pairs. And so when we're reporting a DNA sequence, rather than reporting a string of over 700 bases, we compare a profile to what's called the Cambridge reference sequence. So when you're providing mitochondrial DNA profile information, what you're reporting is the difference that you see between the sample that you're looking at in the Cambridge reference sequence.
And when we look at the analysis that you performed in this case, will we see that comparison with the Cambridge sequence in your work?
Yes, that's reported in a table form that would show the specific locations along the molecule where there was a difference between the item that we're looking at in the Cambridge reference sequence.
Thank you. And can you, in terms of processing, can you walk us through the process of actually sequencing mitochondrial DNA in the lab?
Yes, so there's 3 steps in the laboratory, and the first one is extraction, where you release DNA from the cells, and then you would purify it or separate it from other cellular debris, such as proteins. The second step is amplification, and we use PCR or polymerase chain reaction to make several copies of our region of interest, and again, that would be hypervariable regions 1 and 2. And then the last step, you incorporate fluorescent dyes for each of the 4 bases, and this is used to determine the order or the sequence of those bases along the DNA.
Let me ask you this, Ms. Dimmick. Can you do this process and sequence and develop a profile even with very small hair samples?
Yes, actually, we've had significant success with hairs as small as 2 millimeters or even slightly under that.
And have you even published on exactly that topic?
Yes, yes, we have. We have a publication that involves a 19-year-old homicide that involved 114 hairs that were measuring 1 centimeter or less. And of those 114 hairs, there were 21 that we were able to develop a partial or full mitochondrial DNA profile for.
Okay. Now, before we get to the next slide, can you explain the difference for us between what's known as a question sample versus a known sample?
So a question sample is typically an evidentiary item where you're not sure where it originated from, so it's called a question sample. A known sample, you would know the source of that sample or perhaps the person that it originated from.
So as we're talking through these issues and see some of these terms in your reports, might a question sample be, for example, hairs collected at the scene of a crime?
Absolutely.
And could the known sample be hair or other biologic material collected or obtained from a potential suspect?
Yes,
Okay.
it could.
And can you explain for us how, what the process is for comparing the question sample from the crime scene versus the known sample from a potential suspect?
Yes. So when we're working in the lab, we process samples individually and one at a time. This eliminates the concern for a sample switch, for example. But while we're working with that one sample, we would work with the first question item, and we would carry it through the laboratory process of extraction, amplification, and sequencing. And following the laboratory portion, we determine the sequence for the question items. Once we have the sequence for a question item, we then do the same process for known samples. And again, each known sample is handled individually and one at a time. And we generate the sequence information. The following step would be the comparison of these two sequences.
And when you compare the sequences, do you actually compare the base pairs between the question sample and the known sample?
That is correct.
Okay. And if the question sample from the crime scene, for example, matches the known sample from the suspect, what's the significance of it?
So if we have an evidentiary item and a known individual that have the same mitochondrial DNA sequence, we would compare that sequence to a known database of mitochondrial DNA sequences that are generated from a random sampling of the population. And based on the number of observations of this particular sequence in the database, we can make a general statement about how common or rare a particular mitochondrial DNA profile is in the general population.
And let me ask you this. Is mitochondrial DNA testing used by the prosecution in criminal cases as part of their case to establish guilt?
So they would
object to that, Judge. That calls for a legal conclusion on her part as to what prosecutors use it for or how that happens. I don't think she can testify to that.
Just rephrase the question.
Ms. Dimmick, have you yourself testified as an expert witness using your analysis of mitochondrial DNA? Have you testified for the prosecution as part of their case in establishing guilt?
So mitochondrial DNA is certainly a piece of the picture. It would have to go along with means, motive, and opportunity because it can't identify a specific individual. But from our analysis, we can determine if an individual could be excluded
Okay.
as being the contributor of an evidentiary item.
And that was what I was going to ask you. Can a person be definitively excluded by virtue of mitochondrial testing?
Yes.
And tell us about the concept of using statistics and basing your analysis upon confidence intervals and what you do with those numbers.
So if an individual, again, cannot be excluded as a contributor of a sample, we want to determine how common or rare that profile is in the general population. And we use a database because not everybody has been tested. So based on the number of times that a particular profile is present in a database, we can calculate out a very conservative frequency estimate. And what we use is called a confidence interval. So we'll look at a 95% confidence interval and look at the upper bound number of that interval, again, to determine a frequency estimate. But by looking at a 95% confidence interval, you're allowing for a 5% chance of uncertainty within the general population because, again, not everyone has been tested. So it is common scientific convention to present the results at a 95% confidence interval, the upper bound frequency of that. You can also look at the upper bound frequency of a 99% confidence interval, which leaves a 1% chance that the frequency of this particular mitochondrial DNA type in the general population may be slightly higher than we've estimated.
And we'll talk about this in a little more detail, but did you do that statistical analysis in this case?
Yes, we did.
Okay. And before we talk about this case, a couple of more questions for you. Number one, how long does it take to extract and sequence and analyze a sample and generate a profile?
So it depends on your starting material, depends on what you're looking at and how highly degraded that may be. But just a general range, maybe 2 days to a week. If you have something that's highly degraded, it may take a couple of weeks.
And is there usually a backlog where the company has to work through its existing testing before it can turn to a new specimen?
Yes, our laboratory in particular, right now, we have about a 2 to 3 month backlog for cases.
How much does it cost to do an analysis for a single hair sample?
So a single hair, current pricing is $3,000 per hair sample.
So if you had 10 different hair samples from 10 different suspects to analyze, would that be $30,000?
That is correct.
And do you know what the charge was in 2001?
I'm going to object that is not relevant to this issue.
Yes, Your Honor, it is relevant to establishing whether it was reasonable to expect Mr. Perry or frankly anyone else to request this testing of the hundreds of suspects who were looked at in this case.
Objection. And my objection stands, Your Honor. In this particular case, as she's already testified, there was an agreement and testing was done in 2001. And so that would defeat defense counsel's argument.
You asked him what the bill of rate was in 2001.
Yes, sir.
Oh,
Ms. Dimmick, would you like me to re-ask the question?
Oh, I wasn't, yes, please.
Do you know what the charge was in 2001 for analysis of a single hair sample?
Yes, in 2001, it would have been $2,500 per hair.
Thank you very much. Now, let's discuss the mitochondrial DNA analysis that was performed in this case. You mentioned briefly at the beginning that Mitotyping Technologies was involved in conducting the analysis of the case back in 2001, right?
Correct?
That's when your company was jointly hired by Mr. Johnson and by Mr. Perry's legal counsel.
That is correct.
Okay, and did Mitotyping Technologies, did you all create a report of the analysis and the results conducted of the hair and blood samples back in 2001?
We did.
And did you also create a report this year for the most recent analysis of a known sample?
Yes, we did.
And when we're talking about the two reports that were done, as an accredited lab, does Mitotyping Technologies issue reports when they do an analysis of a sample?
Yes, actually, that's an accreditation requirement, and we do that just as a general practice of business. If we are requested to do an analysis, we would issue a report for the findings of that analysis.
And are those reports, including the two we're going to talk about here today, are they generated at or near the time of the analysis?
Yes.
Or the reports made by someone with personal knowledge and who has a business duty to report the information as you were just walking through?
Yes.
Were the two reports we're going to talk about kept in the course of a regularly conducted business activity?
Yes.
And was the regular practice of that business activity to make the reports we're going to talk about today?
So again, the end of that question was a little bit unclear.
Sure. Was it the regular practice of the business activity at Mitotyping Technologies to make the two reports we're going to talk about here today?
Yes.
Your Honor, at this time, I've marked exhibit number 3 and removed for its admission that is a September 21st, 2001 report from Mitotyping Technologies.
Mr. Johnson?
May I see that, please?
Yes, absolutely. Yes, please. Here's the
Thank you. No objection, Your Honor.
Please submit without objection.
And I've also marked as exhibit number 4, Your Honor, defendant's exhibit number 4, the March 24th, 2020 report from Mitotyping Technologies, which I provided a copy of counsel.
Mr. Johnson?
No objection, Your Honor.
Defendant's 4 is submitted without objection.
And would Your Honor like a copy of the reports?
Please.
May I approach?
Yes, sir. You have one. Thanks.
Does she have a copy?
She does. I'll make sure she can. Load it up. Okay, Ms. Dimick, we are going to pull up first. We can get our technology loaded real quick. We're going to pull up first the 2001 report, and I'll have a few questions for you about that, okay?
Okay.
All right, first of all, if you'll confirm the date of this report and who it was sent to.
So I believe you asked who the report was sent to, is that correct?
Yes, and the date of the report.
So the date of the report is September 21st, 2001. And a copy of the report was sent to John B. Johnson III, as well as Dale G. Westling.
Okay, and we were just talking just a minute ago about the concept of question samples and known samples. Did you receive question samples and known samples from the district attorney's office in 2001?
We did.
Okay, and can you describe what was received? Mr. Watson, if you can zoom in on that, please. If you can describe what your lab received from the district attorney's office in 2001, please.
Yes, so we received via a trackable overnight courier a sealed envelope, and inside it contained one cardboard box labeled JBJ SL, I believe that's in OE WGW WRM, which contained 2 purple top tubes of blood from Dennis Perry. And this sample was designated 2155K1. The 2155 is the notation of the case number for mitotyping technologies. We also received a brown foil envelope labeled 5851096 from number 11, which contained 2 glass microscope slides. The first microscope slide was labeled 5851096 from tape on glasses. And that slide contained 1 mounted hair. It was given the designation 2155Q3. The second glass slide labeled 5851096 from tape of right temple inner piece contained 2 mounted hairs. The larger of the hairs was given the designation 2155Q1, and the smaller hair was given the designation 2155Q2.
Okay, so if we zero in on the 3 hairs under item number 2, the 3 that were marked as having come from the glasses found at the crime scene, are those what you would refer to as the question samples in this case?
That is correct.
And are the question samples received from those hairs what you're comparing other known samples against?
Yes, so we would generate a mitochondrial DNA profile from these evidentiary items, and then we would compare it to the mitochondrial DNA profile of a known individual.
And we'll talk about this, but the 3 hairs you said were labeled 2155, and then there's Q1, Q2, and Q3, right?
Correct.
Were you able to generate any mitochondrial DNA profiles from the 3 hair samples Q1, Q2, and Q3?
So we generated a full profile for 2155Q1. So that is that 783 bases in length. We were only able to generate a partial profile for the 2155Q2 sample, which was about 615 base pairs in length. It was all of hypervariable region 1 and part of hypervariable region 2. And we were unable to generate any profiles from the 2155Q3.
Okay, so you have a full profile for 2155Q1 for 783 base pairs, right?
Correct.
And a partial profile for 2155Q2. And how many base pairs were you able to generate a profile for?
Actually, if I could refer to the report in front of me from the case file, I can give you that number exactly, if that's permissible.
With the court's permission?
Yes. Objection. The objection.
Okay.
So refer to her file.
I don't object.
And actually, you're also highlighting it up on the screen as well. Yes, that Q2 hair, there was 615 base pairs
Okay, so
that we were able to evaluate.
with a full profile of 783 base pairs and a partial profile for 615 base pairs, did you have enough information to be able to conduct an analysis and comparison with these question samples against known samples?
Yes.
Okay. And by the way, you said that you received these samples from the district attorney's office via sealed envelope and overnight mail. Is that the standard way that your office receives samples?
Yes, typically items are sent to us via an overnight carrier by a trackable method so that you're able to monitor the movement of the evidence until it was received at the laboratory.
Okay. And for the 2 question samples, for which you have a profile, the full profile, which was Q1, the partial profile, which was Q2, did DNA, the mitochondrial DNA for those two hairs match each other across the regions for which there was information to compare?
Yes, the 2155 Q1 and the 2155 Q2 matched at all locations for which there was information between the two samples.
Okay. And then did your lab compare the mitochondrial DNA profile from the two hair samples against the known sample from Mr. Perry, specifically his blood sample?
We did, and that's the table that we're looking at right now.
Okay. And based upon your analysis, would Mr. Perry be included or excluded as a source of the hairs, the question samples, the hairs found on the glasses at the scene of the crime?
So Dennis Perry, as well as all of his maternal relatives, would be excluded as the contributor of the 2155 Q1 and 2155 Q2 hairs.
Now, after you did that analysis, after your lab analyzed the sample from Mr. Perry against the hairs found at the crime scene and excluded him, did the district attorney's office contact your lab and hire it to analyze additional known samples from other suspects?
Yes, there were resubmissions regarding this case.
And how many resubmissions were there?
There were a total of 4 other known samples submitted for testing.
And those would be 4 other known samples of biologic material from 4 other suspects.
Yes, I have to refer to my case folder. I believe they were all buccal swabs.
And what were the results of those analyses?
So we generated a profile from the 4 other individuals for which samples were submitted, and they were also excluded, them and their maternal relatives were excluded as contributors of the 2155 Q1 hair and the 2155 Q2 hair.
Okay. Now, let's move forward in time to your 2020 report. If we can pull that up, it's been admitted as exhibit number 4. Ben, can you pull up the top of that, please? The item of physical evidence and background. Zoom in on that. All right. Can you tell us, Ms. Dimmick, when you received evidence or material in this case this year?
So we received evidence March 3rd of 2020.
And what did you receive and from whom did you receive?
So again, the package was sent via an overnight courier. This time it happened to be FedEx. And we received from Ronald Gross of Irmo, South Carolina, a sealed mailing envelope that was labeled in part hair sample from Gladys Sparre.
Sure, and is that the same way that the materials were sent to you back in 2001, except for a difference between the company that delivered?
Yes.
And to be clear, the hair sample that you received from Gladys Sparre, would that be referred to as what we call a known sample?
Yes, because it's from a known individual.
And can you tell us what you were asked to do with the known sample, the hair sample from Gladys Sparre?
So the laboratory was asked to develop a profile from a hair of Gladys Sparre and compare that to the mitochondrial DNA profile that was generated for the 2155 Q1 hair and the 2155 Q2 hair.
Okay, and were you able to actually do that? Were you able to generate a profile for Mrs. Sparre's hair sample and then actually compare it to the question samples from the glasses?
Yes.
And when you did that comparison, when you compared Gladys Sparre's hair sample against the hair found in the glasses at the scene of the murders, was there a match?
So the mitochondrial DNA profile of the 2155Q1 hair, the partial profile of the 2155Q2 hair had the same mitochondrial DNA profile as Gladys Sparre in the regions that were compared between samples.
Okay. Let's talk about the work that you did to reach that conclusion that the profiles matched and what it means for this case. First of all, let's look at your report on page 2, the top end of the first paragraph. Can you tell us whether you were able to generate a full profile for the hair sample from Mrs. Spalding?
Yes, we were.
And you analyze for DNA according to standard protocol and the processes and procedures you've been talking about today?
Yes.
And if we can look at the table below that, and are you able, Mr. Watson, to highlight the known sample that we're talking about? Is that doable? Ms. Dimmick, at the bottom of this table in your report, you have a row titled 2020-004K1. Do you see that?
Yes.
And above that, you have rows that say standard 2155Q1 and then 2155Q2. Can you describe for us, when we're looking at this table, what those rows are referring to?
Yes, so again, that standard in this table is the Cambridge reference sequence, and the numbers, the 16069, 16126, that represents specific locations within the mitochondrial DNA. So we are looking at that one site, and what is listed here for the samples would be where there is a difference between the reference sample, the Cambridge reference sequence, and our test samples, the 2155Q1, 2155Q2, as well as the 2020-004K1. So again, this is a shorthand notation. Rather than having our 783 base pairs all listed out, or in the case of Q2, it would be 615 base pairs. This is simply a shorthand of notation of where our samples differ from our standard, or the Cambridge reference sequence.
Okay.
For both hypervariable regions 1 and 2.
So when you're actually comparing the Gladys Sparre hair sample, is that the one at the bottom that's highlighted?
Yes.
And you're comparing that against the two hairs found embedded in the glasses next to Harold Swain. Are those the two rows immediately above that, Q1 and Q2?
The evidence that we received were identified, yes, as the hairs removed from the glasses. But as to where they were located, I can't tell you where they were located at the crime scene. But yes, those are the hair from the glasses left at the crime scene. And we are comparing it to Gladys Sparre's known sample.
Okay, and can you please walk the court through the results of the comparison that you performed?
Yeah, so at all locations compared between and among the samples, we have generated the same profile. So for example, at location 16069, in the standard, there is a C. In all of the samples that are listed in the table, there's a T found at that location, and so on. And so we're listing all of the sites within hypervariable regions 1 and 2, and we're making that comparison. And the profiles are the same at all compared positions.
And you mentioned a minute ago that this table that you have in your report is sort of a shorthand example of the full profile. Did the profile from the hairs from Gladys Sparre matched the 2 question samples from the glasses across all 783 regions for the full profile and all 615 regions for the partial profile.
Correct.
And so, what does it mean then that the Gladys Sparre hair sample matched the question hair samples from the glasses?
So again, when a question item and a known sample have the same mitochondrial DNA profile, first of all, the known individual and their maternal relatives cannot be excluded as a contributor of the question items. And once again, to put statistical number or significance to these findings, we would search a database for the profile in common with these samples. And when I say in common, what I mean is we did search a database to determine how common or rare this particular profile is in the general population. When we did that, because we were asked to do the comparison from the 2155Q1, 2155Q2, and the 2020-004 known sample, we searched the partial profile region, which was 615 bases, because that is the information that is common between these 3 samples.
And well, first of all, can you tell us the results of your statistical analysis? First of all, did you conduct a statistical analysis to determine how frequently the mitochondrial DNA profiles that we're seeing here occur in the population?
We did.
Okay, and what were the results of that analysis?
And so again, I would like to refer to the case folder, if I may, for the specifics of that.
Go ahead, Ms. Davis. Thank you.
And so when we searched that partial profile common to these samples, it was found in the database 35 times, looking at the Northern American population. And the number of samples that are in the database is 12,386. So again, this particular profile was observed 35 times in that database.
And tell us what that means for the purposes of your conclusions.
And so again, we would use a statistical calculation of normal approximation, and we would look at the 95th percent confidence limit or confidence interval. We're looking at the upper bound frequency of that. And based on this information, you would anticipate the general population frequency of this mitochondrial DNA type to be 0.83, which means that you could exclude 99.62% of the population as having this particular mitochondrial DNA type.
And what confidence interval is that, Ms. Dillon?
It's for the 95th confidence interval, and we're looking at the upper bound frequency.
And if we were looking at, and that's for the hair for which there is a partial profile, right?
That is correct.
If we apply that analysis to the hair with the full profile, what are the numbers then?
So if we look at the 95th percentile for the full profile, the population frequency would be 0.26%. For the full profile. That is correct. The population frequency would be estimated at 0.26%, and it would exclude 99.744% of the population as having this type.
So when we say 0.26%, can you tell us in plain terms what that means with respect to whether?
So another way of looking at this is that if you randomly went out and sampled the North American population, for every 10,000 people, you would expect to see this profile 26 times.
Okay. Out of 250 people chosen at random, how many people would be expected to match this mitochondrial DNA profile?
That would be less than 1. If we're looking at the full profile.
Okay, if we're looking at the partial profile, out of 250 people chosen at random, how many people would you expect to match this mitochondrial DNA profile?
If you're looking at the partial profile, you would expect to see 1 out of 250 people chosen at random within the population to have this particular mitochondrial DNA profile.
Let me ask you this. Do you use this exact same type of analysis and these statistics when you were testifying for the prosecution in criminal cases?
Yes, there's nothing subjective about our methods. So the same statistical evaluation would apply to any samples in which we find a match between a question item and a known item.
Okay, and last subject matter, Ms. Dimmick, we've been talking about Gladys Sparre and the match between her hair sample and the question hair samples from the glasses. And you alluded earlier to the concept of maternal lineage as it relates to DNA testing. When we're talking about mitochondrial DNA, is mitochondrial DNA inherited from the mother?
That is correct.
Is a match to the mother a match to her son?
As long as they're biologically related, you would expect to see the same type in a mother and her children, so yes.
And if we assume that Gladys Sparre had a son named Erik Sparre, what would you expect to see if you compared his mitochondrial DNA profile to the DNA obtained from the glasses?
As long as it's her biological son, you would expect them to have the same mitochondrial DNA profile.
Across all 783 base pairs or regions for the hair sample where you were able to run a full profile?
Correct.
And across all 615 regions for the hair sample where you had a partial profile?
Correct.
So based on the DNA analysis that you did in this case, can Erik Sparre be excluded as a source of the question samples, the hairs embedded in the glasses?
No. Gladys Sparre and her maternal relatives, and if you want to look specifically at her son, would not be excluded as a contributor of the 2155Q1 hair and the 2155Q2 hair.
And Ms. Dimmick, have all the opinions that you've offered here today been held to a reasonable degree of scientific certainty?
Yes.
Thank you very much. No further questions.
Cross-examination, Mr. Johnson.
I guess my question, Ms. Dimmick, is, in this particular case, did in fact, and as far as your analysis is concerned, is Erik Sparre the only person who contributed to the hairs that were questioned in this case, Q1 and Q2?
So I'm having a little trouble hearing you, so if I heard you correctly, you're asking if Erik Sparre is the only person that we could contribute these crime scene hears to, is that correct?
Yes, ma'am. Is he the one who contributed them?
So mitochondrial DNA analysis is not a unique identifier. So again, it's inherited from mother to child, unchanged. And anyone along a maternal lineage will have the same profile. So we can't link a specific individual to a crime scene here.
So the answer is that Erik Sparre cannot be determined to be the person who contributed that hair, correct?
He would be not excluded as a contributor,
I ask you-
but we can't say specifically that the hair derived from him.
Okay. Because if he had a brother, it could be the brother.
Correct.
If Mrs. Sparre's mother had a daughter or had who had a son or who had a daughter for that matter, it could have been them, could it not?
Again, it can be anyone along a maternal lineage. So any siblings will have the same mitochondrial DNA profile. Maternal cousins will also have the same mitochondrial DNA profile. Again, anyone along a maternal lineage would have this profile.
And actually, you found that there were at least, out of a population of 12,000 people, there were at least 35 other groups or strains or lineages that had the same exact Q1 and Q2 profiles, correct?
Yes, but when you search the database, it was found that the mitochondrial DNA profile of the question hairs were observed 35 times out of 12,386.
And who did they belong to?
Pardon me?
Who did those 35 sequences belong to?
So the database is anonymous. It's generated from randomly selected individuals in the population of Northern America.
So right now, we just know that there are 35 other paternal or maternal strains that could have contributed this DNA, correct?
So there were 35 observations in the database that matched this particular profile.
So my question was, there are 35 other strains that could, other maternal DNAs that could, groups, lineage, that could match this hair, correct?
So all of these individuals are of the same maternal lineage. Somewhere back in history, they probably had a maternal relative in common. And that could have been as long ago as 1,000 years. So they're not different types and they're not different strains. They have the same mitochondrial DNA profile.
Your confidence rate of the, I believe, that you indicated 99.6%, that would be at the 99% rate, is that correct?
So I didn't quite hear your question. Could you repeat that?
At the 99%, I'm sorry, at the 95% confidence level, you indicated that that would be approximately equivalent to 26 people out of every 10,000 people is what you would expect statistically this sequencing to appear. Is that correct?
So again, I'm going to refer to my case folder. So since we were asked to compare the profiles from the question items in the note sample, we looked at the partial profile.
Excuse me,
Hold
ma'am.
on one second, hold on 1 second, all right.
Okay.
Hold on.
Ma'am, I
Just
asked you a
hang on a
simple,
second.
I'm sorry.
Repeat your question, Judge.
Judge, I asked a simple question.
Repeat.
That is, you stated earlier that at the 95% confidence level, that would be equivalent to you finding approximately 26 people out of every 10,000 people that were sampled. Is that correct?
If you took a random sampling of the population for every 10,000 individuals, yes, you would expect to see this profile 26 times.
And if there are 340 million people in the United States, that would equate to over 8 million folks that could possibly contribute this strain of DNA at the 95% confidence level, correct?
That sounds about, so if you're looking at 340 million, I'd actually have to grab a calculator to calculate that out, if that's all right.
That's fine. I did it by hand on the paper.
If that number comes out to 8 million, yes, you would expect to see it that many times, but you would also be excluding 332 million as having this type.
But the point is, there could be as many as 8 million people out here who we don't know that contributed to this hair.
That is correct.
And we know that you cannot say definitively, one way or the other, that Erik Sparre contributed to this hair, can you?
Mitochondrial DNA is not a unique identifier, and so no, we can't say that this hair specifically originated from him.
I want to go back to 2001, Ms. Demi. You indicated earlier to defense counsel questions that DNA typing was done on 2 separate occasions by your lab in 2001, correct?
In 2001, for this particular case, there were 5 different submissions.
Okay. And all of those submissions were done, as far as you know, because I believe you said it, by agreement between defense counsel and the state. Is that correct?
We had a court order that came with the first submission of the evidence that specifically addressed the evidentiary hairs and the Dennis Perry known sample. Those were the only items that were addressed in the court order that we received for the agreement of prosecution and defense to work together. The additional submissions were done so by the prosecutor.
You testified earlier that the submissions were done by the agreement between defense counsel and the state. And I'm asking you, you testified to that. So back then, in 2001, you could have tested anybody's hair by agreement between the state and the defense. Is that correct?
If I'm understanding your question correctly, when you say anybody's hair, we tested the crime scene hair and specific known samples, or a known sample.
Ma'am, if Erik Sparre's hair had been, or DNA had blood or whatever, had been sent to you in 2001, you could have tested that in 2001, could you not?
So we tested samples in 2001.
Ma'am, I asked you a simple question.
I object, put it with off.
Just rephrase the question or restate.
Yeah, and I'm sorry, you're breaking up a little
Okay.
bit on my
Yeah,
end, so I'm not
Just try-
100% sure what you're asking.
Okay, he's gonna try to speak up and he's gonna restate the question.
I can speak
Okay.
on, Ma'am, in 2001, if you had received hair or blood or anything biological from Erik Sparre, you could have tested that in 2001, could you not?
Yes,
Okay. You did not receive it then, did you?
that is correct.
However, in 2001, the technology of testing DNA existed at that time for mitochondrial DNA, didn't it? Did it not?
Yes.
That's all I have, Judge. Thank you.
Can you redirect?
Briefly, Your Honor, if I may. Okay, Ms. Dimmitt, first of all, just to orient ourselves, can you tell us when mitochondrial DNA testing and analysis was first available for use in criminal cases in particular?
Did you ask when mitochondrial DNA analysis was first available?
Yes, ma'am, approximately.
It would have been the late 90s, approximately 1997.
Okay. And in terms of the math that you were asked to assume, you said you didn't have a calculator to run statistics that you used in this case against 340 million people. Do you remember that?
Yes.
Can you, and I want to make sure we're clear on what that number actually is, because you were represented that it was 8 million people. Can you use your calculator there with the court's permission and calculate the number of people in this country that can be excluded from this DNA profile using the numbers you used for the full profile? If that makes sense.
It does, for the full profile.
Yes.
So again, when you're looking at the full profile, it was observed 25 times out of 12,386 profiles that were in the database. At a 95% confidence interval, you would expect a frequency of 0.26 of this particular type. And so if we use our calculator, 340 million. Okay, so you would expect to see that in 884,000. So if we subtract that from our 340 million, so there would be 339,116,000 people that would not have this profile.
That you could exclude as being a match to the mitochondrial DNA.
Yes.
And the number that you could not exclude would not be 8 million, but 884,000, right? Now that you've had a chance to use a calculator.
Yes.
And that's across the entire country, right? Throughout the United States.
So that's the North American population, which is the population that we're looking at.
Okay, the North American population. And you mentioned that you can't link it to a specific individual, but in this case, the Sparre mitochondrial DNA profile match that from the mitochondrial DNA profile found in the glasses?
Yes, we can't link it to a specific individual because of the inheritance. But Gladys Sparre and her maternal relatives cannot be excluded as being a contributor.
Now, I want to go back to something you said earlier in your direct, that you are using exactly this sort of analysis when you're testifying for the prosecution in criminal cases, but you said there were other factors you have to think about when you're deciding whether you're identifying a specific person or not. Do you remember that?
I do.
Okay, and can you tell us what those other factors are?
It's in the course of an investigation. Mitochondrial DNA analysis cannot stand alone. It is simply a piece of the puzzle. It's not as powerful statistically as nuclear typing, but it's much more powerful than something like blood grouping. And again, so it won't stand alone. Typically, you would have something like means, motive, and opportunity from the investigators that would accompany the mitochondrial DNA findings.
So means, motive, and opportunity. So you would pair the DNA evidence with other evidence in the case.
I'm sorry, you broke up right at the end.
Would you pair the DNA evidence with other evidence that you have in the case in determining whether someone can be identified?
I believe I heard you correctly. We're comparing the mitochondrial DNA profiles of the evidence sample in the case to a known individual.
No, I have been told, yes, actually the microphone that's picking you gentlemen up is on the monopad. So if you just direct your voice towards the monopad, I think it'll be easy. Yes, sir.
Okay.
I think that'll be easier for her to hear.
I can do that. I thought it was here.
I did too, until 5 minutes ago.
Thank you. All right, is it okay if I stand here?
Yes, sir. That's fine.
All right, so when you're talking about using the mitochondrial DNA profile and using it along with other evidence in the case, such as means, motive, and opportunity, are you using both the subjective evidence of the DNA profile and the other evidence you have in the case to determine who best fits that picture from an identity perspective?
So we only look at the mitochondrial DNA analysis, but if this was presented in court, it cannot stand alone because it's not a unique identifier. It would typically go hand in hand with something like means, motive, and opportunity. Again, we're not involved in the investigation of a crime, so we're a private laboratory. We receive samples for testing. And we do the portion that's requested of us.
Okay. Thank you very much, Ms. Dimmick. Your Honor, those are all the questions I have.
Ms. Johnson,
Limited means, motive, and opportunity, Your Honor.
if you'll just make sure you direct your voice towards the Thank you.
I'm glad to know that's the microphone, too. As many communicated that DNA is used in conjunction with other items. Where there is no motive, no connection between the parties, no information that would show the presence in the community at the time the crime was committed, DNA evidence takes less of an importance than it does whenever there is motive. Is that a correct statement?
Your Honor, I object. She just said she doesn't know any of those factors.
He asked a general question, Judge.
Go ahead.
I asked a general question.
If she can answer.
You said it has to be used in conjunction with everything else. Where that does not exist, means, motive, opportunity, it has less of a lot. It means less to the case, does it not?
So again, we're DNA experts, and so I'm using an example of what our results could go with. I'm not actually involved in the investigation as far as, if we presented with means, motive, and opportunity. But as far as our DNA findings, if somebody was shown to not have means, motive, and opportunity, assume that would be critical to the case. But again, this is we're not involved in the investigative end of things.
Anything else, Mr. Johnson?
No, Your Honor, thank you.
Counsel?
No, Your Honor,
Thank you. Can be excused.
Yes, Your Honor, she can.
It's a good time probably for us to take a lunch recess. Do y'all need more than an hour? Is an hour sufficient, counsel?
An hour is fine with us, Your Honor.
It's gonna move?
That's fine.
All right. If, I would ask that y'all, if you want to leave your belongings in the courtroom, it's fine, but if you put them in your chair, a clean crew's gonna come through during the lunch recess, sanitize everything. That way I think that might look for
Am I assuming that I'm still under sequestration?
No.
Or am I released?
I would ask that Mr. Johnson be released. I'm not going to call him as a witness, and I need him as co-counsel.
Okay. All right. Ms. Holiday, you did not call Mr. Johnson as a witness.
Your Honor, could we discuss that at lunch?
Yes,
Because
that's
a lot
fine.
depends on the
We'll take
waiver
that up.
argument and the way it was made.
We'll take that up when we get back. And we'll see y'all now.
Thank you.